Democratic stalwart David Cicilline and Republican firebrand Matt Gaetz had several dust-ups in the House Judiciary Committee in 2022. Cicilline, a Rhode Island Democrat, repeatedly clashed with the Florida conservative, leading to a wealth of viral moments, tense interchanges, and occasionally outright explosive arguments. Both men boast a take-no-prisoners attitude in Congress's arguably most dramatic committee. Cicilline and Gaetz agreed on almost nothing, fighting over the Department of Justice, critical race theory, Hunter Biden, and more. 2023 will likely offer more battles between the two.
To the gentleman from Texas's comment about why don't we just wait till we understand all the facts of Uvalde with some more investigation underway. He acted as if we've had two shootings in America, two mass shootings, and we're coming to respond to that. We are responding to thousands and thousands and thousands of shootings in this country over the last decade. And so what have been developed here are developed in response to a gun violence epidemic. And the idea,
will the gentleman yield for 10
I will
seconds?
not yield. The idea that we should wait while we can have families that have lost loved ones who are expecting Congress to respond.
Time belongs
and the
to the gentleman
idea, as
from Rhode
Mr.
Island.
Roy suggested,
Wait
that we
before
should just
commenting on
wait
something
to
you don't
find
know the
out.
facts about.
We should be we've waited too long already.
I'm
We
not talking about
failed
waiting
to
about
respond to the
legislation.
cries
belongs
of
to the
people
gentleman
all
from
across
Rhode
this
Island.
country who have asked and demanded that Congress act. So no, we shouldn't wait. We shouldn't wait another second. We shouldn't wait another minute,
you don't know
another
what
day.
happened
We
in
should
Uvalde.
act now. The second thing
You don't
is
know
my
the
friend
facts.
and colleague from Colorado just made reference to this suite of bills as shallow and inconsequential. Shallow and inconsequential. I'm going to go through just a few pieces of this. Ghost guns were used in a shooting in Santa Clara, California that killed 3 people and injured 3 others. Ghost guns were used in November of 2017 in Rancho Tehama, California that injured 18 people. Another shooting in Santa Monica, California that killed 6. Bump stocks were used, as we all know, in Las Vegas that killed 60. Shootings that involved people under 21 years of age. Robb Elementary School, as we know, Uvalde, Texas. Tops Friendly Market, 10 were killed. 22 were killed in Uvalde. Santa Fe High School, 10 were killed. 13 were injured. Parkland, Florida, Marjorie Stoneman Douglas High School, 17 were killed. 17 injured. Newtown, Sandy Hook Elementary School, 27 children were killed. In Columbine, 15 people were killed and 24 were injured. Those individuals would not have been able to buy the gun they bought if the bill that we're going to pass today were the law. Safe storage, the list goes on for pages. So to say inconsequential when it would have saved the lives of many, many people, and as Chairman Nadler said, even if it's one life. So to say it's inconsequential and then to say, let's talk about border security and abortion because all we want to do is avoid responsibility to act in the face of gun violence in this country. Shame on our colleagues. If you don't want to talk about it, you don't want to address it, don't come to the hearing. But honor the memories of those who we have lost to gun violence by taking this issue seriously and being committed to finding solutions. Do you think a grieving mother or father who's watching you wants to hear you talk about abortion and border security? We're trying to respond to gun violence that led to the death of their child. That's what this hearing's about. These families, and sadly there are thousands of families across this country who fall into this category, who have suffered unspeakable pain because Congress has failed to act, and our Republican colleagues in the Senate in particular, in blocking any progress in reducing gun violence in this country. We owe it to their memory. We owe it to the oath that we have taken to protect our constituents, our most solemn responsibility. And people talk about the Second Amendment. We've heard it again today. It's a constitutional amendment. You can't touch it. That is not true. The Supreme Court of the United States has told us that.
Will the gentleman yield?
The Supreme Court of the United States has made it clear that Congress has the authority to impose reasonable restrictions to protect the life and the safety and the security of those we serve. In the same way you can't yell fire in a crowded theater. There is no constitutional right that is absolute. It is balanced with responsibility.
Would the gentleman yield
And
on
so
that
all
point?
these claims about, gee, we wish we could do something. We wish we could remove America from this terrible distinction of being a country that has a gun violence epidemic unlike any other country in the developed world. And by the way, if more guns were the answer, we'd live in the safest country in the world. There are more guns in America than people. Our country is awash in guns, and it has produced more and more and more death and more gun violence. So that's not the answer. We've tried it. It doesn't work. We need real solutions so we can go back to our districts and demonstrate to the people we serve we've taken some action that's going to make a difference and help protect lives in communities all across this country. And with that, I yield back.
Gentleman yields back. Gentleman from Florida, for what purposes? Gentleman from Florida seek recognition.
Strike last word.
Gentleman is recognized.
He said it right there. What they're upset about is the number of guns in the country. This isn't about, modest age restrictions that are unconstitutional. It's not about better record keeping. They want fewer guns. They think that the answer is fewer guns. And that is what is creating a lot of discomfort among our fellow Americans who cherish their guns and cherish their Second Amendment rights and have actually committed no crimes.
They cherish their children, Mr. Gaetz?
You know what? Their children aren't the ones at risk as a consequence of
All
law-abiding gun owners.
children in America are
That's
at
what
risk.
You get wrong. It's not law-abiding gun owners, David. Okay?
Were those children in Uvalde
The gentleman
at
from
risk?
Florida
Here's
has
the
the time.
tension. Here's the tension, okay? You guys are spasming into this reflexive response, and you call it an emergency hearing, right? And the basis for the emergency is what happened in Uvalde. And we all agree it was awful and tragic, but you are not providing the thoughtful solutions that would actually reduce the likelihood of that. When you make an argument in the Judiciary Committee for a change in the law, there are two components. You have to demonstrate a need for the change, and that what you're bringing forward will actually affect that in a positive way. And it's the second part of the argument where the bills you've presented today undeniably fail. And in Florida, I would suggest we had a process that's a little bit better than what we've observed here. In Florida, following Parkland, every Floridian wanted to reduce the likelihood that that could ever occur again for precisely the reasons that animate your passions today. But instead of rushing to town, stumbling bills together, we got our very best sheriffs, our very best police chiefs, former members of law enforcement, people with tactical experience, even parents of slain children. And we put them on a board to review a school shooting as if it were an airline crash, dispassionately, thoroughly. And then as a consequence, what we saw was actually a failure in law enforcement. That the sheriff in Broward County was so recalcitrant in not doing the training, that the on-the-ground law enforcement were so derelict in their duties that children died that didn't need to. And so Governor DeSantis rightly fired that sheriff, replaced them, put better training in, more money to harden our schools and our synagogues, our houses of worship across the state of Florida, and we're safer as a consequence. So it's not that we're particularly here to talk about abortion or the border. We understand we have to make these things less likely, but whether it's you holding an emergency hearing to respond to a leaked draft opinion that's not even final, or now when the Congressman Roy from Texas says, gosh, before you have the emergency Uvalde hearing, maybe we ought to figure out what happened in Uvalde so that we can make that frequency less likely to occur. I think there's also a balancing of interests here that the American people need to understand. You say if it saves one life, anything that saves one life is totally worth doing. And certainly every loss of life is tragic, and certainly every preventable loss of life is tragic. But Mr. Cohen gave up the game earlier when he said, we acknowledge on the front end of this hearing that there will be deprivations of liberty to law-abiding people, that we will at times stop law-abiding people from doing what is otherwise constitutionally legal. So while I certainly want every American to safely store their firearms, while I certainly want every American to be trained on the safe storage of firearms, I'm not entirely sure that the Congress of the United States is the appropriate entity to tell Americans how to store firearms and then punish them as a consequence. And if the result of all of this is there's a a life or two that we save, and the result is, like, how many tens of millions of Americans are you willing to deprive of their constitutionally guaranteed liberty in order to achieve that objective, when there might be a more narrowly constrained, appropriate way for gun enthusiast groups, hunting clubs, local government, states, to try to educate and encourage proper safety of the storage of firearms. So again, we share your goal of making these shootings less likely, whether they be in our schools or elsewhere in our communities, but we don't think that in the name of saving one life, that fundamentally constraining the rights of all Americans is necessary, especially when we are still awaiting the results of the review of what happened in Uvalde that shocks the conscience of all of us. So please spare us the spirited screaming. We want to stop the violence. We just wish you would listen to some of the ideas that we think would help. And from my standpoint, if you hold schools out as gun-free zones, as soft targets, you make those school shootings more likely. And I don't think you want to do that. But I think that if we got rid of the gun-free zones and if we empowered people that could be helpful, we might see a reduction in violence. I yield back.
Gentleman yields back. For what purposes? The gentleman from New York seek recognition.
Move to strike, Mr. Chairman.
The gentleman is recognized.
The gentleman from Florida said that he and his Republican colleagues want to stop.
I thank the gentleman for yielding. I just wanted to respond to the notion that there were some communities that did not have use for this or had a pre-existing system. They're not obligated. This, again, is a voluntary program. It has embedded with it, at the suggestion of law enforcement, the ability to develop best practices if people want to use voluntarily. But the IPAWS system, which is the most sophisticated geolocation infrastructure available, it makes that available to local police departments, law enforcement agencies who want to use it. If they decide they don't have to use it. But if they're a community that decides it would protect the lives of police officers and members of their community, it allows them to do it. It allows them to avail themselves of best practices. It doesn't empower the Department of Justice. It doesn't force any prescription on anyone. It is a common sense idea. This is a public safety bill, as Chairman Jeffrey said, about what can we do to reduce the chance that members of law enforcement or members of the community unknowingly go into a place of danger. That's all, plain and simple. I thank the gentleman for yielding, and I yield back to him.
Thank you. I yield back the balance of my time.
Gentleman yields back. Who seeks recognition?
I seek recognition.
Who?
I do.
For what purposes Mr. Gaetz seek recognition?
Strike the last word.
Gentleman is recognized.
I'm unaware of circumstances where this particular solution would be responsive or helpful. It seems in a lot of these active shooter situations as if notice is not something that impairs any sort of law enforcement response. And perhaps I would stand to be corrected if there are circumstances that Mr. Cicilline would like to highlight for me as I consider how to vote on the bill. I would also observe that Mr. Massey made the point that if it is an active shooter alert system, the places that have embraced the most gun control and the places that have simultaneously defunded police at the local level in some woke reflexive action, they would see that alert go off with such a frequency that one might not even be able to receive other messages on their phone. And then our colleague from New York, Mr. Jeffrey, said, well, what you're really afraid of is growing diversity in the country, which I found a little bizarre, because I don't think that what people are most afraid of in Chicago is diversity. Like, I don't think people are worried that lurking around the next corner, diversity might mug them or shoot them or harm them in some way. I think what they're concerned about is a criminal element that is out of control, and that I think we all wish that, criminals wouldn't ever use guns in the commission of crimes, but it seems as though even the most aggressive, even the most woke gun control is unsuccessful. And so I think our pitch to the people in Chicago and everywhere else in Democrat-run cities and states is, what do you have to lose? What have these Democrats done for you to improve your safety or your quality of life? And their message to you is, be afraid of those who are afraid of diversity.
Mr. Gaetz, will you yield? You asked a question. I'm happy to answer.
I would on the factual.
So I'll give you 4 examples, just I think where an active shooter alert would have made a difference. In February 2016, an active shooter in Kalamazoo, Michigan killed 6 people. The Kalamazoo Department of Public Safety issued a warning on its Facebook page, but few saw the post. The shooter picked up new Uber passengers for 2 more hours after the shooting before his ultimate arrest. In August of 2019, a shooter in Midland and Odessa, Texas, murdered 7 and wounded 25 people across 15 miles, including 3 police officers. Police had information on the shooter's description and location, but no way to effectively alert those in the area to take cover. In March of 2021, a shooter in Atlanta, Georgia, targeted 3 spas, killing 8 people over more than an hour, and was at large for 3.5 hours before law enforcement apprehended him. And finally, in April 2022, a shooter in Brooklyn was at large for 24 hours after shooting civilians in a subway station, and was caught after someone called police to report the shooter after hearing about the shooter's description in alerting systems and reporting. And finally, if you get back to Buffalo, Brandolyn Capehart and Shane Hill, both 20, pulled into the parking lot just as the shooter was exiting.
Well,
they described him as a white male in his late
Cicilline, I'm going to
teens.
reclaim my time so that we can have a productive discussion on this. In those circumstances, before you get to Buffalo, is it your contention that if everyone received a notification on their phone of a shooter, that would have resulted in a more thorough and effective response?
It would have resulted in 2 things. It would have prevented people from unknowingly going into an area of risk. And some of them, it would have prevented people from getting into an Uber with that shooter driving the car.
Were any of those people harmed?
Well, I mean, the idea is we're trying to prevent people from being harmed.
I agree. I'm just
And
trying to
you're saying it's
go
okay
through-
to have someone who's an active shooter run around for hours undetected?
When
that
did I
you should
say
be
that?
willing to
David,
no.
when did I say
Gentlemen,
that?
yield.
When did I? Oh, no,
so
no.
you're
Wait,
saying
hold on. When did I say that?
Well, you just said, did he shoot anyone? What we're trying to prevent is harm or the
yeah, but-
danger of additional harm coming. And notifying people so that they know someone is out there who's been engaged in an active shooting is a way to protect themselves. It's a way to protect law enforcement. It's a way to help identify this person.
Yeah,
There's no harm come to it.
My concern is that in some of these high crime areas where those alerts would be going out nonstop, would you create unnecessary panic? Would you put people in harm's way unnecessarily? Would you encourage vigilantism? And so I ask those questions sincerely because I'm still trying to decide.
Yeah,
how
I
I'm gonna
think
vote
the
on them.
reality is you want people to have accurate, timely information. I think people expect
That they
law
can
enforcement
use, right?
expect. What's that?
My concern is it information that people can use effectively?
Yes, because it will tell them where the incident is occurring, that there's a danger, and then they can make a decision. Do I stay in my house? Do I go to the supermarket? No, it's a way of giving them information about where an active shooting is underway so that members of law enforcement don't unknowingly go into it and members of the community don't do the same. It's very simple.
It sounds a lot scarier than
The gentleman
diversity.
yield.
I think my time's expired, but if the gentlelady will claim time, I'd be happy to engage in a colloquy. I have 1 second, so. Yeah, I'll yield it to you.
Gentlemen, the gentleman's time has expired. Who seeks recognition? What purpose does Mr. Roy seek recognition?
Move to strike last word.
And I reserve a point of order.
A point of order is reserved. The clerk will report the amendment.
Amendment to the amendment and the nature of a substitute to H.R. 8227 offered by Mr. Buck of Colorado.
Without objection, the amendment will be considered as read. The gentleman has 5 minutes to explain his amendment.
I thank the chair. Like my first amendment, Mr. Chairman, this is a clarifying amendment. We've heard concerns, particularly in the ranking member's opening statement, but from others also, that this bill could impact the ability of parties to enter into post-dispute NDAs. While I don't believe the bill as drafted would pose that problem in any way, I want to make it abundantly clear that post-dispute NDAs are not covered by this bill. My amendment also includes a clause to ensure nothing in the bill limits states' ability to legislate regarding post-dispute NDA provisions. And I, at this point, would recognize the gentleman from Rhode Island if he wants to enter into a call.
Yes, I thank the gentleman. I appreciate the concerns of my colleague. To be clear, the bill only prohibits the use of NDAs before a dispute arises, which is triggered by the filing of a lawsuit under a state, federal, or tribal law. Nothing in the bill prevents parties from voluntarily agreeing to a settlement that does not include an NDA. In other words, this bill is carefully tailored to prevent sexual predators who are rich and powerful from evading scrutiny for their misconduct by buying the silence of survivors. And this concern, as you know, is not theoretical. Harvey Weinstein paid the survivors of his horrific abuse hundreds of thousands of dollars to silence them. His settlements included strict NDAs that prevented survivors from making their experience public. These clauses were drawn broadly, preventing employees from speaking to anybody, friends, family, press, public, private, about the alleged behavior, but also about their time at Miramax, according to one of Mr. Weinstein's former associates. During our hearing, Tatiana Spotswood testified that her abuser, former Affinity CEO Zia Chisti, used confidentiality clauses in her employment contract to keep multiple instances of overt sexual harassment and violent assault hidden while Ms. Spotwood's allegations were arbitrated. She testified that as the CEO of the company, he had power over my life and career, and I was anxious not to insult him or make him mad. And while she received a settlement in arbitration, his lawyers offered to give her father $1 million in addition to her arbitration award to prevent the case from becoming public. She was only able to come before the Judiciary Committee about her employer's abusive behavior and make her story public after receiving a congressional subpoena compelling her testimony. So those are two clear recent examples that strongly caution against preventing survivors from coming forward before a lawsuit is filed. Having said that, if the gentleman is willing to withdraw his amendment, we will continue to work in a bipartisan way after the markup to address his underlying concern before the bill comes to the floor.
I thank the gentleman, and I reclaim my time. At this point, I'm not going to withdraw. I will allow hopefully more debate on this issue, and if we can strengthen this amendment in some way, I'd like to see that, and then I will consider withdrawing at that point. So I yield back, Mr. Chairman.
Gentleman yields back. Who else seeks recognition?
I do.
For what purpose does Mr. Gaetz seek recognition?
Move to strike last word.
Gentleman is recognized.
So there's a fundamental misunderstanding about the operation of the bill and the operation of the amendment. Mr. Jordan took the position that the bill bars certain pre-dispute non-disclosure agreements. And Mr. Cicilline just said that the bill does not do that. And the misunderstanding comes with when a dispute arises, that can occur before a lawsuit is filed. I've litigated a number of these cases in private practice, and it is a fiction to say that the dispute arises at the time that somebody goes down to the courthouse and files a pleading. That has never been the case in any one of these matters that I was involved in litigating, and in almost every circumstance I'm even aware of, there are pre-litigation demands. And what the legislation does currently, and majority staff agrees with this, the sponsors of the bill agree with this, that currently the way the bill is drafted, you are robbing victims the ability to enter into a non-disclosure agreement post-dispute, but pre the filing of a lawsuit. That is, we should all agree to that. That is what the effect of the bill is. Now, the reason the Buck Amendment, I think, resolves a lot of those concerns is that it clarifies that your dispute can occur, the event of harassment can occur, and that you still have the full complement of rights after this bill would become law that you do today to enter into a non-disclosure agreement. I can't imagine the sponsor of this bill would want to go from a circumstance where today there's a window of time in this horrific series of events where someone could enter into a non-disclosure agreement and that we're taking that away from people. I don't think that's the case. So I support the Buck Amendment. I think the Buck Amendment would probably get a lot more people to support the underlying bill. And
Mr. Gaetz, would you
yeah,
just,
sure.
I'm trying to understand what your concern is. So if you have an individual who is a survivor of sexual harassment or sexual assault in the workplace who has not yet filed a claim and there is no NDA agreement, there is nothing in this bill that would, of course, prevent that survivor from settling a potential claim and saying, I will not sue you if you pay me X amount of money, et cetera. So there's that ability of the survivor to decide whether to disclose or not remains with the survivor.
But the ability to enter into a non-disclosure agreement,
well, it wouldn't be a non-disclosure, it would be a settlement.
But the settlement agreement couldn't involve a non-disclosure agreement that would be operational.
And there is nothing in this legislation that would bar that.
I don't think that's the case, Mr. Cicilline. I think that if you look at the definitions
there's
on
nothing
page
in this
2,
legislation
section 3,
that
line
has,
13,
but
they
this
talk
is about a settle. In the example I just gave you, that's a settlement of a potential claim. There's nothing that would prevent the parties from agreeing not to discuss it once they've reached a settlement.
Mr. Cicilline, active harassment occurs. No lawsuit has been filed, but a demand has been made to resolve the dispute with money in exchange for a non-disclosure agreement. If this bill in this form were to become law, that would not be allowed. And I think that's what your colleague is sharing with you now.
Will the gentleman yield for question?
I'll yield to Mr. Goldman.
Yeah. When this says that with respect to a sexual assault dispute or sexual harassment dispute, no pre-dispute non-disclosure or pre-dispute non-disparagement clause, so when does the dispute begin?
See,
Does that begin when you actually notify the employer that that employer has sexually harassed you, or does it begin when the incident? I think this language is much too vague and probably should say something like before the incident giving rise to the dispute, because this is very vague and it's going to cause a lot of heartache.
I think Judge Gomer has rightfully isolated precisely the issue. And in many areas of law, the way we mark the incident is when the facts give rise to a claim, right? When a claim arises from the event. And so I think of when the dispute begins at the time of the offending conduct, not at the time of the filing of the lawsuit. And so, again, I believe there's a high probability that this legislation is going to become law in some form. And so we offer these suggestions, and I think the Buck Amendment is offered so that
The gentleman would yield for one more
achieves that
time.
objective.
Just to be clear, in the bill that is before the committee, that question that Mr. Gomet raised is answered in Section 3. The pre-dispute non-disclosure clause means a provision in a contract agreement agreed to before a lawsuit is filed. So that's the triggering mechanism. I think the problem with the amendment is if it included access to counsel so that the determination is made with consultation with counsel, I would have less concern about the abuse of that process.
I just feel like if we compare this experience to like the arbitration experience, the cake is not baked here. The way I felt like we were a lot further along in understanding.
Which is why I think we can work out Mr. Buck's concern if we have a little more time on this issue before it comes to the floor. But I think we basically agree, and I think it's just a question of sort of fine-tuning the language. And I've had the privilege of working with Mr. Buck on so many issues. I'm confident that we can resolve this one.
We'll try to keep an eye on him over here.
Gentleman's time has expired. Who seeks recognition? If no one else, then the question occurs on the amendment.
Mr. Chairman,
The amendment is withdrawn. Are there any further amendments to the amendment in the nature of a substitute?
Yes, Mr. Chairman, I have an amendment at the desk.
The gentleman will, the clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 8227, offered by Mr. Cicilline of Rhode
Without
Island.
objection, the amendment will be considered as read, and the gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. This is a technical amendment that will insert language used in the definition of pre-dispute non-disclosure clause to Section 3.2, the definition of pre-dispute non-disparagement agreement. All this amendment will do is ensure that non-disparagement clauses, which can prevent survivors from making any negative statements about their abusers or employers, regardless of whether the statement is related to the nature of the dispute, are given the same treatment as NDAs under this law. So this is a technical amendment. I urge my colleagues to support this and yield back the balance of my time.
The gentleman yields back. Is there any discussion of this amendment? If not, the question occurs on the amendment. All in favor say aye. Aye. Opposed, no. The ayes obviously have it. Are there any further amendments to the... Someone want to talk? I'm sorry, Mr. Gomet. We'll withdraw the vote. Mr. Gomet is recognized.
Thank. Yeah.
Oh, the amendment is agreed? The amendment is considered as read, and the gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. This amendment limits the opportunities in the legislation for expungement to those who are U.S. citizens. When I originally reviewed the bill, I thought it purported to be a right-on-crime bill, and I wanted to be open-minded and think through many of the points that have been made in debate today. But what I've come to learn is that this bill is actually an immigration bill in drag. And the provisions of the bill that would limit the ability to ascertain whether or not an offense had been committed by some government officials would limit the ability to decipher where there had been disqualifying offenses for immigration into the United States. For example, if a consular's office was determining whether or not to grant a visa to a non-U.S. citizen who wanted to come to the United States, they would not be able to have full access to that information. And with an immigration system right now in shambles, with a border that has been converted to a turnstile, I don't think we should make it harder for the administration of an immigration system that would stop people from coming to our country who are not U.S. citizens and who have committed otherwise disqualifying offenses. That's the amendment. I yield back.
Gentleman yields back. I recognize myself in, does this gentleman insist on his point of order?
I do not, Mr. Chairman.
The point of order is withdrawn. I recognize myself in opposition to the amendment. This amendment is completely, frankly, absurd. The expungement provisions have nothing to do with whether someone is a citizen of the United States, and considerations behind them have nothing to do. I'm sorry, the sealing provisions have nothing to do with the citizenship of someone in the United States, and has nothing to do with immigration. If someone lawfully present in the United States commits a crime, then under the same circumstances as any citizen, his crime, his record should be sealed. If his record should not be sealed, under the same considerations as any other person. If the person is unlawfully present in the United States, he should be deported. But this amendment has nothing to do with any of that. I don't understand the point of the amendment. A record should be sealed.
Chairman, yield?
Yes, I will.
Because the bill covers them. If they're if they're in the United States unlawfully and they are convicted of such a crime and they stay around for the year, they get the benefit of this bill, don't they?
Sealing does not expunge the record, and DHS can still access the record.
Well, I understand DHS, but the public can't.
Also, neither can a
The public should not be able to, under the same considerations as anybody else. And of course, if the person is undocumented, they can't legally work in any of it.
Will the chairman yield for a question?
Yes, I will.
How would a consular's office access that information under the provision that would allow the DHS to?
It allows for investigation. The answer is that the bill allows for investigations under such circumstances.
Would the chairman yield for a follow-up question? So, as the chairman reads the investigation provision, it's your belief that that provision applies to an investigation that a consular would do on an immigration matter, not necessarily an investigation into criminal conduct. I'm just trying to understand how you see the word investigation playing out practically.
Well, wait a minute. The consular office is part of the Department of State, and wouldn't do an investigation if the country's already if the person's already in the country. DHS, however, can do such an investigation.
No, but it's just not relevant.
Yeah,
It's just not relevant.
Well, but would a consular's activity to determine this information be considered an investigation within the construct of the bill? And I ask that question because it seems...
Yes.
But it seems as though the bill, and I believe Mr. Bishop has the provision, limits that investigation to law enforcement activity. And if the consular's office is in the Department of State doing that immigration activity, it is modified by whether or not it's law enforcement.
It does not. But if you'd like an amendment to clarify that point.
But Mr. Chairman, if you look at
There's a law enforcement function within the
page
state.
7, line 15. Page 7, line 15 is where you see that it has to be a law enforcement activity, and it's only below that on page 7 at line 22.
And the State Department is able to...
I yield to the gentleman from
The
Rhode
State
Island.
Department has the ability to do and performs law enforcement functions. So it's not limited to just an agency. It's a law enforcement function, which would cover any law enforcement function of any department. And Mr. Chairman, if you'll yield, you are absolutely right. This has nothing to do with immigration. Don't struggle too hard to try to figure out the amendment. This is an effort to take a piece of legislation that will make communities safer by allowing people to successfully re-enter and jam in an immigration question so they can be on Fox News talking about immigration. Let's be honest. I yield back.
Gaetz' time, right? Oh, then I'll yield back to. Does anyone else seek recognition? For what purpose does Mr. Johnson of Louisiana seek recognition?
Strike the last word.
Gentleman is recognized.
Yield to the gentleman from Florida.
I'll assure my friends and colleagues that one does not require a right-on-crime bill to go on Fox News and talk about immigration.
Oh, we know that.
One would simply have to go to Martha's Vineyard.
We understand.
And see deportation work.
See human trafficking at work. Yes, no question about it.
Efficiency.
Yes.
But back to the bill at hand. My concern is that on page 7, if you go to line 22 where it talks about the investigations, that is all shelled within what constitutes law enforcement activity. And while I heard the gentleman from Rhode Island assert that the activities of a consular when evaluating a visa request from someone from India would somehow be considered law enforcement, I don't think that's true. I don't think that's clear in the legislation. I think there's no law one is seeking to enforce. There's no criminal matter. It's a determination as to whether or not one can come in the country. I would yield to the gentleman from Rhode Island if he would like to maybe point out what I've missed there.
No, I'm happy. I think the legislation makes it clear that for law enforcement functions and determining whether or not someone is lawfully in the United States has a law enforcement component, it would be covered by the proposed legislation.
Okay, yeah, I don't think that's true. And then here's what the American people need to know about this bill now, okay? This bill is not for, the person who as a teenager made a mistake and now wants to contribute to society and we want to create a good on-ramp to a productive life. Now what the bill is it is a shield for people wanting to come to our country who are not citizens so that we don't get to know the full picture.
Will the gentleman yield I don't want you to... I'm sorry?
It's actually Mr. Johnson's.
Oh, Mr. Johnson, will you yield?
I'll yield.
Okay, just to be clear, this statute is not available for people outside of the United States. So this argument that somehow people want to come to the United States are going to go to court and get something expunged before they arrive here, that simply isn't true. So this notion that somehow this is helping people come into the United States, not true.
Okay,
if you are outside the United States, you are not eligible to get an expungement for something that happened in the United States.
We are almost at bump stock level of misunderstanding here, my friend. There are, I know this may surprise some, but there are people who actually come to the United States, leave, and then seek to come back. And so the scenario I'm describing, let's say someone from India had come to the United States, had committed an offense, availed themselves to the provisions of this bill, went back to India, wanted to return with a visa. There is no way the consular's office would be able to get that information in this bill, which means this bill is now a shield for people who are not citizens of our country, not our fellow Americans. It's about something vastly different. I'll yield back to the gentleman from Louisiana.
Yield, Mr. Bishop.
I think the gentleman from Louisiana. I'll give an example. In North Carolina on August 12, 2 illegal aliens murdered a sheriff's deputy in Wake County. It's since emerged in news that they have a brother who also is in North Carolina, also illegal, entered as an unaccompanied minor. He's been arrested for possession of ammunition by an illegal. If he had the conviction on that, as best I can read under this bill, because there are exceptions for firearm possession and there's exception for explosive materials, but this individual, this illegal, he'd be entitled to expungement of a conviction within a year for that offense, as best I can tell.
Would the gentleman yield?
It's not my time. I'll yield back to Mr. Johnson.
Yeah, I think that analysis is right, and in the 1 minute I have left, I cannot help but share the data that we got this morning that should be the most alarming thing among all the conversations, and that is that we have shocking numbers. We're talking about the border here and illegals coming in. We have shocking numbers of known terrorists who are now entering the country every day.
Would the gentleman yield?
I will not. We've caught 78 this year alone. And what we all know here, all of us know,
matter of time.
The Biden administration has no idea how many are here among the 1 million plus gotaways who've entered streamed over the border, how many terrorist cells are set up. And as this gentleman, Tom Feely, who's the former director of New York ICE Removals, New York, he said this morning, we'll never know they're here until it's too late. This is happening. Everybody knows it. Administration, Secretary Mayorkas, doing nothing about it. I'm not sure there's anything more important that we could discuss. I yield to Mr. Bishop. You have something else?
The only thing I'd add is if a bill like this